somewhere.
Silence, all stand. This honourable court's now in session. Please be seated.
In the matter of Josephine Davy Green and others, and the Minister for Mining and Industry.
Yes, I apologise for the delay. That matter had to be adjourned over from this morning.
Your Honour, it's obviously an important matter. I was going to take Your Honour now to the decision documents for the decisions that were made on the 13th of November 2020.
Yes.
The first document I'm going to go to is not in Your Honour's hard copy bundles.
Okay.
So I have it here.
Before we do, can I just make, during the luncheon adjournment, very briefly, because I had other things to do, I started to read through the defendant's submissions to just get an idea of what the parties' positions are. And it is, just as yours are, Mr Jones, your submissions full of acronyms, and I found it impenetrable and very, very distracting and very difficult to follow. Now, these are your submissions, and not a matter for me to tell you how to do them. But if you want to assist me, one way of doing it would be to use the names of things that you're talking about instead of UCPs and VOPs and MMRs, and which I find very, very difficult to follow. Council have been living with this for a considerable period of time, and you know what they all mean, but I don't. And anyway, that's just a request. So, and do with it what you will and what you can.
We will action it, Your Honour. We want to assist Your Honour, and I apologise.
Look, but even in the written submissions, if you do, in addition to the ones I've got, a global replace so that I can follow it easily, that would be of a great deal of assistance from both parties.
Yes, Your Honour, we'll do that.
Okay, now you were going to take me to?
Yes, now there's a further document, Your Honour, and also in this folder are the other documents that I will take Your Honour to that Your Honour does not already have in hard copy.
Okay, thank you. Much appreciated.
And I should say, Your Honour, the last tab in that folder is Chapter 3 of the EIS. I promised I'd give Your Honour a hard copy of.
Lovely, thank you very much.
So the first document in that folder, Your Honour, is the recommendation to the Minister prior to the Minister making her decision. It's headed Department of Industry, Tourism and Trade.
And that's in volume 5, tab 59, right?
Yes, Your Honour.
Okay, that's very handy to know. And that document you're tendering, are you?
Tender that document.
So that would be Exhibit P8. Yes.
Your Honour will see the recommendation, under the first heading recommendation, approve the mining management plan amendment for the MacArthur River mine by documenting your decision on the statement of reasons.
Yes.
Approve the security amount being set at $400 million odd, and sign the variation of authorisation 0059. And then looking under the heading issues, on 31 January 2020, MRM, that's the operator, the company, submitted an amended mining management plan for assessment for approval to replace their approved 2013 to 2015 mining management plan, subject to the Mining Management Act. So that's what the issue was, and Your Honour will see under the recommendation, it's recommended that the mining management plan be approved.
Yes.
And I highlight these passages, Your Honour, because one of the points that's put against me, particularly in relation to the security, is that all that was approved by the Minister in this authorisation were the activities for 2020.
All that was approved to be carried out. Not, so that's the distinction being made by the defendant, I gather, from the brief read that I've been able to have of the submissions, which that's a distinction that's being made. Distinction between being approved in some sense or other and approved to be actually carried out. That's the distinction they're making, I think. Have I got that right?
Yes, Your Honour is quite right in relation, that's the argument they make in relation to section 43A. The reason I was pausing is because they do also say that those 2020 activities constitute what they describe as the metes and bounds of what is authorised.
Yes,
Yes. So,
to be carried out.
yes, Your Honour, that's
All
right.
right.
Now, in my submission, in fact, what's being authorised and approved to be carried out is everything in the MMP, the Mining Management Plan.
So the Mining Management Plan 2020
Yes.
authorises everything in there,
That's right, Your Honour. That's right. And
not just what is to be carried out in the interim.
in 2020, yes, which is my learned friend's case, not just what is to be carried out in 2020.
Okay.
And, Your Honour, one can well understand why the operator would want that, because they're obviously making financial and investment decisions in relation to this mine and are therefore seeking approval for the activities they plan to carry out until they cease taking ore or concentrate out of the mine. Your Honour, the next document is the Statement of Reasons. This is in Your Honour's original hard copy material. It is tab 60 from volume 5.
Got that?
The first volume.
You hang on to those and just give them to me when I... Thanks, Liz. Because I can't reach that far. So, Exhibit P9 will be Volume 5, tab 60, which is called, what is the name of the document?
Statement of Reasons.
Statement of Reasons. Okay, thank you. Thank you. And that will be Exhibit P9.
And again, Your Honour, I show Your Honour this to make it absolutely clear that what approval is being sought for and the approval that is given is for the Mining Management Plan 2020. So one sees in the second paragraph, on 31 January 2020, MRM submitted an amended mining management plan seeking approval to undertake mining activities consistent with the overburden management project, environmental impact statement.
Say that again. What paragraph am I looking at?
That's the second paragraph.
Yes, got that.
Yes. And then, if Your Honour goes down to the third last paragraph on the page, which has the bullet points under it,
Yes,
this amended mining management plan seeks approval for the implementation of OMP EIS related activities, overburden management plan, environmental impact assessment related activities, involving improved environmental management to develop the lead zinc resource previously approved, consistent with the overburden management project. Key mining activities proposed in the amended mining management plan include, and then they're set out. And it's then said over the page after the bullet points.
more exhaustive list of key other proposed activities is at Appendix B.
Yes. And Your Honour has Appendix B. It's volume 2, tab 20 in the first volume that Your Honour has there.
And Appendix B is in Volume 2,
Yes, Your Honour.
tab
20.
20. Is that going to be part of Exhibit P8 because it's referred to or not?
I think it should be a separate exhibit.
All right. Exhibit P9 is...
Oh, I'm sorry, I think we're up to P10.
Oh, sorry, so we are. PN is Appendix B to reasons, is that right?
Yes, Your Honour.
To statement of reasons. Volume 2, tab 20. Yes?
And then staying in the statement of reasons, a couple of paragraphs down, it says approval of the activities proposed in the amended MMP would enable continuation of mining operations.
Yes.
A decision by me as Minister is actioned by, number one, approving or not approving the amended MMP.
Yes.
So that's what's being done in my submission there. And I'll come back, if I could just show you the bits of this, and I may need to come back to it in relation to the argument, but under the findings of material fact, there's a reference to the minister concluding that the plan is compliant with the Act.
Who's this? MRM has submitted for approval. Where does it say the minister is?
So if one looks at the first paragraph immediately after the heading findings on material facts, in making my decision, I have determined the following
Oh,
findings
right.
of fact.
Well, it doesn't say that he's, where does it say that the minister is satisfied?
Oh, these are reasons of the minister.
Yes, but where does, you're saying, right,
So it's the I.
yes, I've determined.
Yes. MR,
And
then
which
it's
fact do you,
then it's the italicized number 1 under that,
All right.
MRM. So the minister.
well, that's what that's, MRM has submitted that. So I find as a fact that MRM has submitted this. Doesn't say I find it to be true.
No, Your Honour, has submitted an amended MMP for approval. That is
Oh,
compliant.
I see. You say that. All right.
Yes.
You say, got you. I understand.
And then over the page, again, point 2, the minister finds the application for the amended mining management plan satisfies the
Satisfies, yes.
requirements of the Act. Heading 3 is concerned with my third issue about Assessment Report 86, so I won't go into the detail of it now. And then heading 4 on 2351 is the security determination. The operator, sorry, this is heading 4, italicised and underlined on 2351. The operator must provide the minister with a security in relation to the planned disturbance of the mining activities pursuant to section 43.
Is there any dispute between the parties as to the appropriateness or lawfulness, I suppose, of using the approved security calculation tool?
No, Your Honour.
Good.
Not put in that way. And the next document, Your Honour, is the authorisation itself, which is tab 61.
Authorisation. Volume what?
It's in volume 5,
Volume 5, tab 61.
61.
Yes, that will be exhibit P11.
If I could just show Your Honour that, it feeds into the points that Your Honour was raising with me about the minister's submission. So on 2356 is the variation of authorisation itself. The only really relevant part of that are the 2 lines right at the end of the main paragraph, where it says omitting the schedule to the authorisation as varied and inserting schedules A, B, C and D attached to this instrument. And then schedule A is the conditions of authorisation. So if I could then ask Your Honour to turn to those conditions, it's part of the same document, and go forward to page 2361. Under the heading General, point 3, condition 3, subject to any conditions contained in the Act and this document, the operator must comply with the commitments and activities contained in the MMP, including the implementation of all systems referred to in the MMP. So the operator must do all of those things. Condition 4, the operator may only conduct mining activities identified in the MMP within the mine subject to any conditions. And turning the page to 2362 under the heading Security and Levy, condition 10, the operator must provide the security of 400 million. And then condition 11, the security provided will be reassessed and may be revised following submission and approval of a third-party assessment, an amended mining management plan, or an amendment to the unplanned closure plan. And then
Is that
condition...
an or an and?
I'm sorry, Your Honour?
Is that an or an and? It doesn't say either. Is it A, B and C, or A, B or C, or what?
I think it's or, Your Honour.
Okay.
Certainly haven't run an argument that it's and. Just pondering whether I regretted that, but no, we say it's or, I think.
All right.
Condition 12, the revised security amount to be provided under condition 10 is to be provided prior to creating the new disturbance.
Yes. Well, that's the defendant's argument, isn't it?
That's their argument, quite. In my submission, that doesn't this combined with the conditions I'm about to show Your Honour just don't comply with the requirements of section 43A.
Okay.
So if Your Honour then goes forward to 96, which is on page 2386.
Mine closure?
Yes, Your Honour. So 96, from the date of authorisation of the overburden management project. Now that date is 13 November 2020, because that's what's happening in these decisions. The operator must submit an updated mine closure plan with each MMP that builds upon the closure concepts I defined in the overburden management project. So that's saying any future MMP needs to have a mine closure plan. Now that, as I'll come onto in a moment, is really a recognition of the obvious fact that the current MMP does not have a mine closure plan.
Let me make a note of that. Okay, thank you.
97 contains what that closure plan, or identifies what the closure plan should contain. And 98 sets a long stop date, as it were, on the finalisation of it. And so it's an exercise, to put it colloquially, in kicking the can down the road in relation to the mine closure plan. And then finally on this, Your Honour, 99, from the date of authorisation, the operator must annually submit an unplanned mine closure plan, which is accompanied by a related security estimate. And as Your Honour has already understood, this is the kernel of the Minister's approach that says it is consistent with section 43A to have a system whereby there is security calculated by reference to the unplanned closure plan at the end of 2020, and every year it's looked at again. Now, in my submission, that's just not consistent with section 43A, but that's the Minister's approach as to how it works. Now, Your Honour, then tab 62 of this same volume, volume 5, this is the notification to the company of its success. I'm sorry,
Notification of approval. The notification of approval, which is, what did you say again, still volume 5, tab
Yes.
62, will be exhibit P12.
Thank you, Your Honour. And Your Honour will see from this letter, mining activities are authorised, A, B, C. and then under that, this variation authorises the additional mining activities associated with the document MacArthur River Mine Mining Management Plan, January 2020. So this is consistent with my submission that what is being authorised are the activities in the mining management plan, not some subset of them.
Yes, all right.
That's that letter. Then next is a memorandum in tab 63, volume 5, tab 63, also in your honours bundle, is a memorandum that I tender.
Memo from Minister for Mining and Industry to Minister for Environment. Volume 5, tab 63 will be exhibit P13.
Grateful. And then Your Honour will see in the first paragraph, I'm writing to inform you of my recent decision to approve an amended mining management plan and vary the authorisation granted to MacArthur River Mining Proprietary Limited under the Mining Management Act 2001, enabling the overburden management project to proceed. On 31 January 2020, MRM submitted an amended mining management plan that proposed the full commencement of works falling under the scope of the MacArthur River Mine Overburden Management Project Environmental Impact Statement. So again, we say that supports what's being approved is precisely what's referred to in those paragraphs.
Yes.
And then the final document, Your Honour, at this time is in your Honour's additional folder that I handed up a moment ago. It should be the second document. It's from volume 5, tab 64.
So, exhibit P14 is, what is it, a letter from?
A letter from the Minister for Mining and Industry to the EPA.
So, and that is volume 5, tab 64. So, a letter from the Minister for Mining and Industry to the Northern Territory Environment Protection Authority, which is in volume 5, tab 64, will be exhibit P14.
And Your Honour, this notifies the EPA of the approval of the mining management plan.
Yes.
It notes in the third paragraph the EPA's assessment, which is Assessment Report 86, and the 30 recommendations. Then the next paragraph, the Department has advised MRM has met the requirements of the Act, and the amended mining management plan submitted by MRM complies with the Mining Management Act. The Department has considered and incorporated all 30 recommendations from the NT EPA Assessment Report 86. And then the next paragraph, on consideration of advice from the Department, I've therefore approved the amended mining management plan and varied MRM's authorisation. Now, as I'll come to in the third issue, Your Honour, if the Minister decides not to incorporate the recommendations from the EPA, the Minister has to tell the EPA that, and that notification has to be tabled in Parliament.
Table what the advice.
The notification, yes, the
The
notification to the EPA of inconsistency with its recommendations.
What's that under?
That's section 8A of the Environment Assessment Act, 1982.
Thank you.
Now, Your Honour, I was then going to turn to the first issue, the closure plan.
Right.
If I could ask Your Honour to take up the Mining Management Act, 2001.
Thank you.
Your Honour already has my submission that we say that the plan that's required is a plan for closure, intended closure at the end of the intended activities. And it is not, as my learned friend submits, any sort of plan that deals with a hypothetical closure.
And you're about to make good that proposition by virtue of portions of the Act, is that right?
That's correct, Your Honour. If I could start with section 40 itself.
Have it?
Yes, I'm sorry, Your Honour. And then subsection 2 sets out the requirements of the plan, and the order in which they're set out underscores the fact that in my submission what's being referred to is a plan for closure after the activities proposed in the plan have concluded. So A is the mining interest, B is the ownership of the mining interest, C is a description of the mining activities for which the operator requires an authorisation. So the mining activities that the operator is intending to carry out. Then D, details of the organisational structure. E, details of the management system. So how are the mining activities going to be carried out? F, plans of proposed and current mine workings and infrastructure. And then it is then that one comes to G, a plan and costing of closure activities. Now, in my submission, the manner in which those subsections are set out demonstrates, is in strong support of the proposition that the closure activities that are being referred to are the proposed closure activities to follow the proposed mining activities. Now,
Yes.
Now, Your Honour, that's supported by the context in which Section 40 sits in the Act. And in that regard, if I could start with Section 16.
Yes.
Obligations of operator. The operator of a mining site must ensure that the environmental impact of mining activities is limited to what is necessary for the establishment, operation and closure of the site. And 2, for that purpose, the operator must, and various requirements, but including C, establish, implement and maintain an appropriate environmental protection management system for the site. Now, that underscores that what's being required and identified in relation to closure is something that is intended to minimise the environmental impact of the mining activities at the end of their extractive life. If one then goes forward to section 42, provides that the operator for a mining site must notify the minister in writing of the proposed cessation of mining activities on the site that is not in accordance with the mining management plan. So implicit within that is that the mining management plan sets out what the proposed cessation of the mining activities are, and that again supports the proposition that the closure that's being referred to is closure after the end of the proposed cessation of mining activities. Then the security provisions, 43 and 43A, I realise this may be somewhat contentious because there's a dispute between us about what they mean, but I rely on these in support of this argument as well. 43, an operator who carries out mining activities under an authorisation must provide the minister with a security, and then
In relation to the activities in accordance with the condition of the authorisation
yes,
mentioned in 37 2B1.
so that's the condition that requires a security.
All right.
And then subsection 2, the purpose of the security is to secure the various matters there set out. And those include, as Your Honour can see in C, the payment of costs and expenses in relation to the minister taking an action to complete rehabilitation of the mining site. Now, it's very difficult in my submission for the minister to assess what costs are going to be required to complete rehabilitation of the mining site without knowing what the operator's plan for closure of the mining site is.
Say that again. You say that the minister can't assess
Yes.
costs and expenses of rehabilitation of the site without what?
Without knowing what the operator's plan for the closure of the site is. Section 46, Your Honour, is the next relevant provision. This is a certificate of closure. On completion of the rehabilitation of the mining site to the satisfaction of the minister, the operator for the site may apply to the minister for a certificate of closure in respect of the site. 2, when the operator has met the closure criteria for the mining site, the minister must A, issue to him or her a certificate of closure, and B, return any outstanding security. And then 3, in this
Sorry, on your argument, this isn't going to happen for 1,000 years.
no closure, that is monitoring post-closure, Your Honour. What's
So, all right, you're saying that the security, I'm just trying to get my head around this, and maybe I've got it all wrong. You're saying that the security has to take into account the fact that there's going to be monitoring between 100 and 1,000 years in the future. And you say that was part of the closure criteria?
I say there's no closure criteria in this mining management plan.
No, but in the proposed, in the earlier version,
Yes, Your Honour.
in the earlier version of the mining management plan that had a closure plan for the end of the mine, it included monitoring for the next 1,000 years. And you say that's part of the closure criteria?
Not necessarily, Your Honour, because Your Honour will remember that table that referred to maintaining water quality. There was the table that said once the water quality is monitored and comes down to a particular level, if it then stays at that level for 10 years, that formed part of the closure criteria in the conceptual mine closure plan.
Nevertheless, what you're saying here is, even though they've got to keep monitoring it for 1,000 years, Well, when do they get their money back? After the 1,000 years or after they've got the, 10 years worth of performance criteria, stability or whatever?
Well, Your Honour, with respect, it's not for me to say. It depends what the
Well-
closure criteria are.
Well,
Now-
weren't you saying that the closure criteria in that draft plan included monitoring so that you've got 10 years worth of stability on various criteria and then ongoing monitoring for 1,000 years?
Yes,
Now,
they do.
on your view, so does this mean they never get their money back or just for 1,000
that-
years or?
That's with respect not right, Your Honour. First of all, it will depend on what the closure criteria are. Now, the closure criteria may be, we are going to put in place, we're going to do X, Y and Z up to a particular date, or we're going to do X, Y and Z up to a particular date when we will stop because the water quality is sufficient, or we will do X, Y and Z up to a particular date, at which point we will have in place a particular system that is going to cater for the ongoing monitoring or whatever it happens to be of the mine. Now, that may be the
And then-
closure criteria.
And then if they don't,
Criterion.
if they decide once they've got their money back, they're not going to do it, then there's no comeback. The security's already been given back. Is that the way it works?
No, Your Honour, because it's only outstanding security that's being returned.
I don't understand.
Well, if money has been put forward by the operator to do a particular aspect of the closure operation that has not yet completed, then the
Yes.
operator will not get that money back until that has completed.
So there's a proportion of the money that won't come back to them maybe for 1,000 years.
Yes, Your Honour.
I see.
The thing is, Your Honour, that only sounds to a degree extreme because of the extreme environmental impacts that the mine is having on the environment. So if one engages in a mining activity for profit that is going to have an impact on the environment for 1,000 years, then one can well understand why the consequence of engaging in that activity for profit is that one is tied in for that period of time.
Yes,
Now,
I understand.
this is a very large mining operation on a very sensitive site. Not all mines are like that. And certainly in my submission, if that is the consequence, that's not one that undermines the construction for which I contend.
Okay,
It
No,
is-
I understand.
It may be something, Your Honour, though, that feeds into this, which is that if an operator puts forward closure criteria, which they didn't in this case, and says, look, we can't hang around for 1,000 years or contemplate the prospect of robots at this stage. So what our closure criteria are going to be so that we can get our money back are X, Y, Z.
Yes,
And that X, Y, Z we can do in 50 years or 100 years. And it'll then be a matter for the minister to determine whether those closure criteria are adequate or not.
yes,
Now, the closure criteria being referred to, as Your Honour can see in 3, is the
Yes.
standard or level of performance as specified in the mining management plan that demonstrates successful closure of the site.
yes,
Now, inherent in that is that there is specified in the mining management plan a standard or level of performance that demonstrates successful closure. That necessarily follows from 3.
there must be in the mining management plan, criteria to demonstrate that will determine whether there has been successful closure.
Yes, Your Honour. Yes. Now, subsection 3 assumes that that is in the mining management plan. The only place in the Act where there's an express requirement that could contain what is here assumed is section 42G, a plan and costings for closure activities.
So you say section 46 has implications for the construction of section 42
very
to
much so.
G,
Yeah.
40 to G.
Yes, Your Honour. Because if 42G doesn't mean what the plaintiffs say it means, and it in fact means what my learned friend says it means, then there doesn't need to be in the mining management plan any standard or level of performance that demonstrates successful closure of the site. So, Your Honour, those are the sections I was going to take Your Honour to support my argument. I also say that it's consistent with the evident purpose of section 42G, which is to, well, I'll show Your Honour the objects. The objects of the Act are set out in section 3.
Yes, I had a look at that. Yes,
Now, those objects include to ensure the development of mineral resources in A, but then B, to protect the environment by, and doing those various things, and one sees in Roman numeral 3, to maintain a management system for the site. And then C, to assist the mining industry to introduce programs of continuous improvement to achieve best practice in environmental management. And then E, to minimise the liability of the territory by requiring payment of security to provide for the rehabilitation of mining sites or rectification of environmental harm.
and you say that can only happen on closure.
It can only happen on closure, and best practice, which is being referred to here, must be that one plans for what will happen at the end of what one is intending to do on the site. And indeed, I won't go back to it, but that's consistent with the references.
Sorry, listen, so it can only be accomplished on closure. And best practice requires planning. That's pretty much what you just said, isn't it?
Yeah, that's right, Your Honour.
Yeah,
And support for that is in the environmental impact statement and the conceptual mine closure plan. Because at that stage, they seem to be following what would be best practice and developing a plan along the lines of what we say was required.
yeah.
And finally, on this first issue, Your Honour, can I show Your Honour Justice Southwood's decision in Territory Iron?
Yes, have you got it?
We don't have hard.
Do I have it? I mean,
No, Your Honour has it electronically, but not a hard copy. Feeling a sinking sense of failure, Your Honour, in not having provided all of the materials. Does Your Honour have an electronic version
maybe, but not accessible to me here.
at the moment?
Yep.
Your Honour,
So,
Your Honour, we'll
I just check we got one? No.
Your Honour, we're going to get a hard copy of
Okay.
it for Your Honour. The decision in
I mean,
Territory,
in chambers I can print it out, but I mean, if you want me to look at it now.
we'll try and assist you, Your Honour. I'm sorry we don't have it. It's also relevant to the second issue.
All
So we can deal with it compendiously and hopefully that area helps.
Do you want to take the afternoon and break and print one out? Or
I'm
not?
happy to continue, Your
All
Honour.
right, okay.
I'm conscious of the need to get through it.
I'll just check, well, yes, all right.
But I'm in Your Honour's hands. If you find it.
No, no.
Your Honour, so that's really the first issue. We say what the legislature must have required in relation to this is an intended plan, not a hypothetical, contingent, unintended plan. The next issue is the security calculations. Now, we make 3 complaints in relation to the security calculations.
Yes,
The first is a non-compliance with section 43A of the Act because security was only calculated and provided by reference to costs that were going to be incurred for an unplanned closure at the end of 2020. and they should have been calculated by reference to the costs referable to the approved activities under the Mining Management Plan 2020.
So costs of closure at the end of all of those. All approved activities in the mining management plan. Okay.
So that's the first issue. Tell Your Honour what the issues are. The second issue is the arbitrary end dates and the 10 years for post-closure monitoring.
Yes.
And the third issue is that in relation to the mine levy wall, the WPORD,
The what?
Your Honour will remember the Western
Yes.
Perimeter Runoff Dam. I'm sorry, I'm not complying with Your Honour's.
No, that's all right. It was a request only. Western Perimeter, something or other.
And the Southern Perimeter Runoff Dam. Those three pieces of infrastructure,
Where does the O come in?
runoff.
WPROD?
Yes.
No, okay. Yes, what about,
We say one can't find any costs associated with their ongoing maintenance post-closure in the calculations.
so continue, what did you say, maintenance?
Maintenance of
Maintenance of those.
those.
Yes.
So the first point about section 43A, can I just take Your Honour back to section 43A in
Yep.
the Act?
Yes, calculation of security.
It really turns on the construction of this paragraph, as Your Honour has already identified. The Minister is to calculate the amount of security to be provided by reference to the level of disturbance likely to be caused by, critically, the mining activities to be carried out under the authorisation granted to the operator.
Now, I might have this wrong, but what's put against you is that to be carried out means that they actually are going to carry these out.
Yes.
And the defendant says, well, the Minister says, well, under that mining management plan, they can only carry out certain activities until there is a new security provided.
No, that's, with respect, Your Honour, that's the argument.
Yes.
That's quite correct. The argument is wrong because what's being approved are the activities in the mining management plan.
Yeah, I know
True it
you
is.
say that that's what's being approved,
Yes.
but can they actually carry out all of the approved activities without further either authorisation or payment or some action on behalf of the Minister?
Yes, they can under the terms of the authorisation, Your Honour. Because Your Honour will recall, condition 99 requires a new unplanned closure plan to be submitted, I think by August each year.
Say under the terms of the mining management plan, they can carry out all of the activities specified in that plan, set out in that plan.
They've been approved.
All right. Now, you were going to take me to section or clause 99
Yes, I was, Your Honour, that was the clause. Don't think I need to go back to it.
No.
That said the MRM needs to submit every year a revised unplanned closure plan.
Yes.
Now, there's nothing in there that says the submission of an unplanned closure plan under condition 99,
Unplanned. Yeah.
unplanned closure plan.
But there's never going to be a planned closure plan.
No, well, that's what's contemplated by conditions 96 to 98. That's the kicking the can down the road point. They're saying, well, we'll sort
96
that
to
out later.
98 says that at some point, but when?
With the next mining management plan, whenever that may be, they're required to submit a mine closure plan.
But there may never be another mining management plan because you say they've already been authorised to do everything.
Yes. And even with these further UCPs that have happened,
Okay.
unplanned closure plans that have occurred, 2021 and 2022, those unplanned closure plans aren't new MMPs.
No.
There has been no new MMP.
So a planned closure plan must be submitted with the next MMP, which may never occur.
Yes, Your Honour, that's right.
And in fact, on present indications, will never occur because they've got,
Well, yes, why? Why would they? There was that long stop date that I identified for Your Honour that I think says 5 years before the end of the mine closure. They need to have a final one. So I suppose...
hang on, just until 5 years before the end of the...
Yes.
And what's to happen then, and what was that?
That's condition 98, and that's the final mine closure plan.
End of the mining operations. C clause 98, final closure plan.
My basic submission in relation to the security is that when one looks at 43A as a matter of ordinary language and asks, well, what are the mining activities to be carried out under the authorisation granted to the operator? The authorisation granted to the operator is for Mining Management Plan 2020. The activities to be carried out
Are all of them.
are the activities in that plan. And one very much doubts whether MRM, the operator, would be happy with a situation where it had only been approved for activities in 2020 and it was just completely unknown whether it would have approval to carry out all of these other activities. It's just not, in my submission, a common sense construction of Section 43A. And I showed to Your Honour the recommendation to the Minister, the statement of reasons, the various letters that followed it. None of those
Limit anything.
None of those said they've been approved up to the end of 2020, but
Yes.
all bets are off after that. They said, great, you've been approved subject to the recommendations. And of course, that's obviously what was happening. And my submission is that what should also be happening with my issue 1 and issue 2 is there's a plan for what will happen at the end. The plan is appropriately costed and the operator pays those costs and security up front before it starts putting the plan into action.
The defendant says, well, we are going to get security for all of the closure activities for the final closure plan. We just get it in stages.
Yes.
We get it in stages because we make sure that we've got security for an unplanned closure in case something awful happens every year. And then 5 years before the life of the mine ends, we get the final closure plan and we take security for everything else that may be needed in relation to that final security plan. What's wrong with that?
Well, it may be legitimate in terms of ensuring that the money is obtained in stages. What it doesn't do is ensure the operator pays upfront for all of the activities that are to be carried out under the authorisation. That's what is being required by section 43A.
Where does it say up front? The minister is to calculate the amount of
Yes.
security to be provided by an operator by reference to the level of disturbance likely to be caused by the mining activities to be carried out under the authorisation granted to the operator. Assume that everything you say about authorisation covering all of the activities in the mine management plan is correct. Where does it say in section 43A that this security can't be taken in stages?
Well, it's a condition of the a mandatory condition of the authorisation that the operator provide the security amount. Now that's 37(1)(b), Roman 1.
Just let me look at them.
Yes.
Thirty-seven.
37, duration and conditions of authorisation. And then 2, an authorisation is subject to the following conditions. B, unless it's the Ranger project area, which this is not, the operator must provide a security in the amount, in the form and on the terms specified in the condition.
Well, why can't the terms specified in the condition be payment over a period of time?
Because the question is whether that is security for the disturbances to be carried out under the authorisation. Now, so that's why I say up front, because it has to be calculated in accordance with section 43A. Now, so one starts with what are the activities to be carried out under the authorisation.
So let me just say, question 1.
Yes,
what are
quite
the
right.
activities?
And and that's really where this case turns. My learned friend says, well, the activities to be carried out under the authorisation are the activities in 2020.
Yeah, well, you say that's not right.
I say that's not right. Now, as soon as one decides that's not right, it means that the security must be calculated by reference to all of the activities in MMP 2020. That's how you calculate the security as mandated by 43A. And then that security, pursuant to the condition in 37(1)(b), Roman numeral 1, must be provided as a condition of the authorisation.
Wait a minute, just let me get the wording of 43A again. 43A. Disturbance likely caused by mining activities to be carried out, i.e. all of them, and what's the next step in your argument? So what are the activities to be carried out? You say all of them under that mining management plan.
Yes.
Therefore, section 43A must calculate the security by reference to the disturbance likely to be caused by those mining activities, that is, all of them.
Yes.
And what's your next step?
And then that security must be provided as a condition of the authorisation.
So if the authorisation, so really your argument is just to do with the calculation of it, because there'd be no reason under that argument of yours why there could not be a condition of the authorisation that the security to be provided is calculated at X, which is a lot more than 400 million, to be maybe amended from time to time and payable by instalments. But you're saying that you have to actually calculate, at least up front, what the X is going to be.
Yes.
By reference to the whole of the activities authorised under the mining management plan.
Yes, that's correct, Your Honour. Now, in relation to Your Honour's, I think, 2 points that Your Honour raised there, yes, it can be subject to amendment. For example, if the plan changes or if there's rehabilitation, so something is done that money can be returned. Can it be paid in instalments? There's no provision for instalments in the Act, and indeed, one of the rationales of this is in my submission requiring the operator to put its money where its mouth is.
Yes.
Right up front. Now, can I just show Your Honour belatedly Justice Southwood's decision in Territory
Thank you.
Island,
Yep.
which is consistent with that submission?
I'm sorry, I just need to check. We've gone past the usual time for the afternoon adjournment. Does anybody require a break? Do any of the court staff require a break? No? Yeah? Council?
No, Your Honour.
All right,
Very
we'll go
grateful-
through.
Very grateful to the court staff in assistance.
Well, they usually are entitled to a 15-minute break in
Why,
mornings and
yes.
afternoons. Thank you.
Territory Island.
Got it? Thank you.
Your Honour, this case was concerned with a slightly different issue to the one we're concerned with. It was about whether the security was allowed to, in 43A, was allowed to capture the costs of fixing past disturbances rather than future disturbances. And
Yes,
as Your Honour can probably anticipate, His Honour found that because it says to be carried out,
yeah, that
it's
they,
forward-looking, not backwards-looking. But there's a great deal of useful commentary in the decision, which is over to, as to what the purpose of section 43A is. And if I could start in that regard with paragraph 23. The second sentence, it is apparent from various sections they're set out, including section 43A, that the security is intended to cover all disturbances to be caused by mining activities to be carried out over the whole life of a mining project, including closure and rehabilitation activities.
yes,
Then going forward to paragraph 62,
sorry, can you? Yes, 62.
62. This is the point I was going to make about my first issue, Your Honour, about closure plans. Paragraph 62, if I could ask Your Honour to look at the last sentence, which begins 5 lines from the bottom of the paragraph. The requirements that the mining management plan is to include a description of decommissioning and rehabilitation of the mining site and a plan and costings of closure activities means that an original mining management plan submitted at the time an operator applies for an authorisation is to cover the whole life of the mining operation.
Yes, okay.
Then 78. Now, Your Honour will have seen...
Just let me find it. Got it. Yep. I will have seen what?
Your Honour will have seen in section 43 that set out the purposes of the security. It said or, so the purpose is to secure A or B or C.
Yes, it does.
And in this decision, Justice Southwood says, well, yes, that may be so, but in fact, the purpose is to secure all of them.
Well, it doesn't say or. It says the or doesn't come after B. It does at the end of B. It only comes between B1 and 2. There's no or between A, B and C.
Yes, Your Honour, which is consistent with Justice Southwood's approach to it and which is something that I endorse.
I see.
So I'm sorry, Your Honour,
I misunderstood
misled Your
you.
Honour in relation to what I said you were about.
Oh, you misled me as distinct from me misunderstanding. Is that correct?
It's definitely my fault, Your Honour. Paragraph 78 deals with this. There are three purposes. This is in the third line down. On their face, there is arguably a disjunction between the purposes set out in A, B and C. Your Honour might perhaps say it's not even arguable.
I don't know, but
However, all three purposes are to be secured by the provision of the security, and to the extent to which the Minister may incur costs and expenses in relation to Roman 1, the Minister taking an action to prevent, minimise or rectify environmental harm, and 2, the Minister taking an action to complete rehabilitation of a mining site, is in many respects contingent on securing an operator's obligation to comply with the Act and the relevant authorisation. If the security is properly calculated for the whole of the mining operation and an operator complies with the Act and the authorisation, it is unlikely that the Minister will have to take action to prevent, minimise or rectify environmental harm.
yes, I see.
81, this is the point His Honour makes about it being forward-looking. And then subsection 43A(1) of the Act requires the Minister to calculate the amount of security by reference to the level of disturbance expected as a result of the planned mining activities which will be carried out in the future under the authorisation. His Honour then says that stands to reason. And then the Act places an onus on the Minister's delegate to as accurately as possible calculate the amount of security required for the whole life of a mining operation prior to the commencement of mining activities. 82.
That last sentence is quite important for a purpose of approach. If the security is inadequately calculated prior to the grant of an authorisation, it will not secure the objects set out in section 43(2) of the Act.
Yes.
Yes.
Paragraph 82, section 43A(1) is found in part 4. When part 4 of the Act is read as a whole, it's apparent that the Act contemplates that an operator is to inform the Minister of the full scope of all mining activities planned to be carried out on the mining site, and the security is to cover the level of disturbance caused by all planned future mining activities, including any disturbance caused by mine closure and rehabilitation activities.
Yes.
And then a few lines down, 5 lines down, the mining management plan must include a description of the mining activities for which the operator requires an authorisation, including a plan and costing of closure activities.
Yes.
Now, when read in context, that supports my position on the first issue. And then the last sentence of the paragraph, the provisions of part 4 give the Minister adequate power to take steps to calculate the amount of security to be provided by reference to the level of disturbance likely to be caused by the mining activities carried out under an authorisation. And then 87. Just in relation to Your Honour's point at 87, 3. So His Honour is there saying in the chapeau of 87, at the last 2 lines, Parliament intended that the risk be managed and contained in the following manner, and then His Honour says at 3, at intervals specified in an authorisation or as required in writing by the Minister, recalculating the amount of disturbance likely to be caused by the mining activities carried out in the future. So that was one of Your Honour's points about if things change, it can be recalculated.
Yeah. When reassessing the level of future disturbances in mining. Right, yeah, okay. So what's been going through my head is this. There would be a difference in kind, would there not, between the kinds of closure, the costs of an unplanned closure, due to a natural disaster or something, and the costs of a planned cessation of mining activities at the end of the life of the mine.
Yes. They're
So
different
it's not
hypotheticals.
just a payment by instalment of the planned closure activities, they're different in kind.
Yes, exactly, Your Honour. Exactly. So you're paying by instalments, but the subject matter is
It's just different.
Yeah, that's right. Yes. And then 88, if the Act were to be interpreted in a way that failed to place an onus on the Minister's delegate to take steps to ensure that the amount of security to be provided by an operator was calculated as accurately as possible in the first place and then regularly reassessed. So that's what's meant to be happening.
There's a greater risk of mining operations
And
becoming
then,
insecure.
The money where your mouth is point is the last sentence of 88. If an operator does not have the financial capacity to provide an appropriate amount of security at the commencement of mining activities, then there must be a real concern about the capacity of an operator to conduct the planned mining activities in accordance with good industry practice. So, as Your Honour is well aware, these mining companies have a habit of falling over or getting into financial difficulty, and the idea is calculate the security up front, make them pay it, and then it can be reassessed as the mine goes on. So that's Territory Iron, Your Honour. I'm still on the first aspect of my critique of the security calculations, and the final thing that I wanted to show Your Honour in that regard to support what I say was the mining activities to be carried out under the authorisation is in the first affidavit of Mr Padovan. That is in Your Honour's hard copy.
Well, just let me... Mr Lloyd, is that affidavit going to be read or...?
Yes, it is, Your Honour.
All right, so there's no difficulty referring to it now? So the first affidavit of
First affidavit of Mr Padovan, which is tab 6.
Okay. Do we have that, Lucy? Do we have that?
Yes, it's volume 1 of the hard copy bundles.
Thank you. Oh, it's in, it doesn't matter. This will do, yes? Yes?
If Your Honour goes forward to paragraph 23.
What's a VOA? Variation of authorisation. Got it?
So Mr Padovan there says, fairly straightforwardly, the current variation of authorisation, that's the one we're discussing.
Yes.
The current variation of authorisation, A, authorises the mining activities contained in the 2020 MMP.
Yes.
And then Mr Padovan identifies what those activities are in paragraph 24. Nowhere there is it said, well, actually, only the 2020 activities were authorised.
Yes.
So that's
I've got
a
it.
cunning argument that in my submission perhaps has been thought up after the event.
B.
Oh, my learned friend wants to identify B. B imposes conditions on those mining activities,
Yes.
including conditions relating to implementing assessment report 86.
Yes.
So my learned friend is intending that to mean that there's a condition that, in fact, activities after 2020 aren't authorised, but that can be developed.
I will hear that from Mr Lloyd when time
So,
comes.
Your Honour has my point that the authorisation isn't limited by reference to the UCP, and it doesn't make sense to say the authorisation is limited by reference to the unplanned closure plan when that is a hypothetical plan that everyone hopes will not occur.
No, but Mr Lloyd's point is that there's an obligation to put in a new one every year, and, well, I don't know what the secondary point of that is. I mean, what would happen if they didn't? Does that mean they can't keep mining, or does that mean that they're just in breach of their obligation?
Well, Your Honour, they in fact didn't. I mean,
But they kept mining?
they kept operating the site. They only submitted the 2021 UCP, I think in March 2021 or April, and it wasn't approved until July. And so, in theory, they were conducting, on my learned friend's case, unauthorised mining activities during that period.
So they didn't submit a new unplanned closure plan on time?
Well, no, they submitted it on time, Your Honour.
Look, whether they did or not is neither here nor there, really.
No,
My question was, what would happen if they didn't? And what would be the legal consequences of their not doing so? Would that mean that they were simply in breach of their obligation to do it? Or would that mean that they were not authorised thereafter to carry out any further activities until they did?
In my submission, the answer is the former. They're in breach of the condition.
Yes.
And the interesting thing as well, Your Honour, about condition 99, it refers to the submission of an unplanned closure plan, but not its approval. So in theory, they could comply with the condition and submit an unplanned closure plan. And there is then a gap of whatever amount of time where it's required to be considered, where they continue mining in accordance with the approval for the project that they've received, which is manifest on the documents what they were being authorised to do.
So there's nothing to say they have to stop mining until that authorisation comes through?
So the scheme that's been adopted in the conditions is simply not compliant with section 43A. It is a different type of scheme that requires a different type of act, not this one. And I should also flag, Your Honour, in section 7...
And what's the consequence of that?
The consequence is that they have not calculated the security correctly.
And the consequence of that is?
That their decision should be quashed and they should be required to remake it so that there's a proper amount of security.
Well, that doesn't necessarily follow, does it?
Well, if the security has not been calculated in accordance with section 43A, there's been a constructive failure to it of the exercise of their jurisdiction in calculating the security.
Yes. But it doesn't necessarily follow from that the authorisation itself is made beyond jurisdiction.
Oh, yes, Your Honour, I'm sorry, I missed Your Honour's point.
There's a
Yes, Your Honour,
gap.
quite. There's a statutory construction question that says, that to this effect...
Wait a minute. To fix security, right, okay, got that. And you say, what follows from that?
First, there is a security decision, so that would fall to be quashed. The next question is, what impact does that have on the authorisation?
Yes, that's my question.
Yes, Your Honour, and that's a question of statutory construction as to whether it was intended by the legislature that if a security had not been calculated in accordance with the requirements of section 43A... That
the authorisation would be void. Do you support the construction that says that was the legislative intention?
Because, Your Honour, in section 37 2B, Roman numeral 1...
Wait a minute, you say legislative intention was that the authorisation would be void.
Yes.
Why?
Because it is critical to any authorisation that a security be provided. That is why in section 37 2B, Roman numeral 1...
Wait a minute. Section 37, 2B, 1.
Is a mandatory condition of every authorisation that a security be provided.
Right.
Now, if
And if there is no security decision, you say that means that there cannot be.
yes,
Right.
and I won't go back to it, but Justice Southwood in Territory Iron explains that it was in the same amendments that introduced Section 43A that this condition became mandatory. I think that was 2013. So it used to be the case you didn't necessarily have to have a security, then that became mandatory in this section, and you had Section 43A introduced that told...
Section 43A and 37(2)(b)(1), i.e. the mandatory requirement, introduced it in the same amendments, you say?
Yes, Your Honour.
And that's set out somewhere in Justice Southwood's decision.
The reference for Your Honour. I take that one on notice, Your Honour.
All right, that's the one, I can find it anyway.
And, Your Honour, just to complete this topic, could I hand up the second reading speech for
Yes.
the Amendment Act?
Thank you. Thank you. Whereabouts, which bit?
Yes, Your Honour. So, Your Honour goes down to the final paragraph on the first page.
New approach to funding, yeah.
At the centrepiece,
Yes, I've got that.
this bill is a new approach to funding these initiatives. The Territory currently requires mining activities to cover 100% of the rehabilitation liability of the environmental disturbance caused by the improved operation. So I rely on that in support of my submission on this issue. That's the only purpose for which I rely on the second reading speech.
There's something, it says, this is on page 1709, section 43 is amended to clarify the purpose of the security, and a new section 43A is added to specify the amount of the security to be provided relates to the level of environmental disturbance for that operation.
And
So presumably the whole operation is intended there.
yes, Your Honour, that's supported by the paragraph on the first page. The reference to Territory Iron,
Hang on, sorry, there is a reference to section 37.
yes, it doesn't cover the...
No,
that
not
reference
your
doesn't
point.
cover the new condition, but that's dealt with in paragraph 21 of Territory Iron.
Okay, paragraph 21, thank you.
So, I'm sorry, Your Honour. Paragraph 21 and then paragraph 23 identifies the amendment which made it mandatory to provide a security to the Minister.
Thank you.
Now, Your Honour, that's the first aspect of security. In relation to the second aspect, which is the end dates, I need to show Your Honour the native Excel file that contains the security calculations.
Okay,
I think we're able to bring it up on the screen. Don't know if that's going to be sufficient for Your Honour's purposes, but I think.
Well, I have a
that's right.
screen here, if I can follow.
Oh, I'm grateful, Your Honour.
What is this?
Your Honour should be looking at the security calculations that were submitted by the operator, MRM.
Oh, wait a minute. Are you going to be tendering this? This is a
Your
piece
Honour,
of
it
evidence?
is volume 5, tab 78.
So exhibit P15 equals, so it's the security
Security calculation.
calculation submitted by the operator, yes?
Yes, Your Honour. And
Wait on, security calculation submitted by the operator, what volume is it in?
volume 5, tab 78.
Volume 5, tab 78, will be exhibit P15. Yes,
This was the calculation approved by the Minister in her decision.
okay. Approved by Minister in decision. Approved.
In her decision, it's called Appendix E, capital E.
What's it called?
Appendix E.
Appendix E, okay. All right.
Now, Your Honour, this
So,
calculation,
is there a hard copy of this somewhere? Or will there be?
there is, no, Your Honour does not have a hard copy of it. It's difficult to manage in hard copy, but we can
Okay.
provide it to Your Honour if it would be.
It would, thank you.
Um,
In due course, I mean, not now.
Certainly, Your Honour. Your Honour, there are various tabs at the bottom.
Can somebody roll it down so I can actually see?
On it, they're at the bottom of the sheet, so.
Can we squish it up? Okay, whoever's controlling it at the bar table, would you squish it up, please? So I can see all the tabs at once.
If you want to.
Well, just the tabs that are going to be referred to by Mr. Jones.
Yes, my learned friends very helpfully provided me with a hard copy, Your Honour, and I think I
That would be
will
very handy.
give that a go.
Thank you. Lovely, that's better.
Now, the second last page of that, Your Honour, should be the tab which is called Post-Closure Water Quality Monitoring Worksheet. And,
Post-closure environmental monitoring.
yes, it's the one after that.
Okay. Post-closure water quality monitoring worksheet, yes.
Right. And so this is what the name suggests. And if Your Honour looks to the second column from the right, it
Yes.
says enter the number of years, 0 to 10,
Yes,
and 10 is entered. The reason why this spreadsheet says enter the number of years, 0 to 10, is because that's what is in the department's security calculation tool. And the operator here has elected to go for 10, so the maximum from 0 to 10. But that's the
so
limit.
that's it, like, there's the maximum you can put in.
Well, you can put in higher numbers, Your Honour.
Okay, you can put in high
And
numbers.
the spreadsheet allows you to put in 50 or 1,000 or whatever.
Yes.
But there's a...
But it says enter the number of years 0 to 10.
So that's what makes good the proposition that water monitoring is limited to, post-closure is limited to 10 years. And Your Honour...
Whereas the mining management plan says that, well, does it say anything? I thought there wasn't anything in the mining management plan about closure.
There is, Your Honour, that graph that Your Honour will recall that had
Oh, yes,
the
okay.
different colours, that's still in the UCP. So the mining management, the unplanned closure plan.
The graph showing 1,000 years monitoring.
Yes.
Still in the unplanned closure plan.
And throughout all of the documents that I took Your Honour to are numerous references that Your Honour noted down, identifying that 10 years is
Not there.
there's no meaning. And this is what then causes us to run this case as either legal unreasonableness or a fettering of discretion, because either there's no reason to have 10 years, it's arbitrary and perverse and lacks an evident or intelligible justification, or what's happened is that someone's looked at the tool and said, oh, well, it says 0 to 10, so
Maximum 10.
go for 10. And that would be an inflexible application of a policy. So it's either one thing or the other.
And you've developed those arguments in your written submissions?
Yes, Your Honour.
Thank you.
And if Your Honour then goes back to the post-closure environmental monitoring, which is the page prior that Your Honour first identified.
Yes?
Your Honour will see right at the bottom, the last two lines in green, post-closure total bracket annual, and then there's a figure of 1 million.
And then 10 years, yeah.
So that's limited in the same way.
Yes.
This one isn't a fettering issue because this tab did not form part of the tool. The operator put it in itself,
Okay.
but it's adopted the 10 years by reference to the water quality. So Your Honour has the point, and there
I
are
do.
various other examples which we identify in our written submissions of other limitations. They all really turn on the same point. There's no justification anywhere in the reasons of the Minister or Maletta Friends admissible evidence for those limitations.
Yes, I understand the point.
And then the third aspect, Your Honour, of security, which I've already flagged, the mine levy wall and the western perimeter runoff dam and the southern perimeter runoff dam.
Yes.
I gave Your Honour the references to the documents which showed those were going to stay post-closure.
Yes.
And we cannot find anywhere in the security calculations any amount that is referable to maintaining those pieces of infrastructure.
Yes.
That's issue 2, which brings me to issue 3, Assessment Report 86. Can I just clarify that Your Honour intends to sit to 4:30? I'm not
Correct.
totally sure of the court sitting time.
4:30.
I should be able to do it in that time. Assessment Report 86, as I'll show Your Honour in a moment, I'll show Your Honour now. The Minister concluded that the mining management plan was consistent with the recommendations in Assessment Report 86. And
Yes.
if I could go to the Statement of Reasons, and this was the part of the Statement of Reasons that I said to Your Honour I'd come back to. It's tab 60.
Is that in this bundle or is it in the new bundle?
It's in the first volume of the first bundle, hard copy bundles. that
I have
was
it.
provided with.
Yeah. Yes, wait a minute. Tab 60.
Volume 5, tab 60. I've already tendered it.
What exhibit number did I give it?
9, Your Honour.
Okay, thank you.
And then if Your Honour turns forward in this document to 2349, Your Honour will see the heading right at the bottom of that page, interaction of the Overburden Management Project with the Environmental Assessment Act, Environment Protection and Biodiversity Conservation Act, and requirements under the Mining Management Act. And then the next page, the amended Mining Management Plan application seeks approval to undertake mining activities under the Mining Management Act consistent with the Overburden Management Project Environmental Impact Statement and associated recommendations in the Northern Territory Environment Protection Agency Assessment Report 86 made under the Environmental Assessment Act. So consistent with, I emphasise. The NT Environment Protection Agency Assessment Report 86 makes 30 recommendations. Next paragraph, based on my requirements under the Mining Management Act to consider the Northern Territory Environment Protection Agency Assessment Report 86, that was section 82, showed you on earlier, I have considered and determined the following. The amended Mining Management Plan seeks approval to undertake activities that are consistent with the Overburden Management Project Environmental Impact Statement and the Northern Territory Environment Protection Agency Assessment Report 86, subject to the Environmental Assessment Act, the outcomes of which I must consider. And then this is where we get to the heart of the issue in the second bullet point. Relevant Northern Territory Environment Protection Agency recommendations included as conditions in Authorisation 59, triggered by the amended Mining Management Plan, have been addressed. There are some differences in tailing storage facility activities described in the amended Mining Management Plan compared to the approach recommended in the Northern Territory Environment Protection Agency Assessment Report 86. In summary, the different approaches put forward in the amended Mining Management Plan are an increase in the tailings storage facility footprint due to measures to improve the structural integrity of the facility and an increased level of detail provided to manage the tailings storage facility in situ in the event of an unplanned closure. These have been assessed as delivering the Northern Territory Environment Protection Agency's overarching environmental outcome of maintaining the MacArthur River. Now, a fair reading of that paragraph makes two things clear. One is that the Minister thought that the amended Mining Management Plan was consistent with the EPA recommendations.
Yes.
And the second is that the Minister thought that the difference was, relevantly, an increased level of detail to manage the tailings storage facility in situ.
Which wouldn't be inconsistent, would it? That were right.
Well, what the Minister seems to have failed to apprehend is that in Assessment Report 86, the EPA said tailings must not be managed in situ.
Oh, wait a minute. Tailings. What's the SF again?
The tailings storage facility.
Storage facility.
Yes.
So the Minister thought that the difference was an increase in the level of detail in managing the tailing storage facility, but the recommendation said they shouldn't be managed in situ, and
they should be transferred to the open pit void.
whereas the MMP 2020 said manage in situ, is that right?
Correct, Your Honour, yes.
So that's not, you say, an increased level of detail, it's just different.
It's totally different, Your Honour, and it's a difference that means the MMP is inconsistent rather than consistent.
Okay, I've got that.
And Your Honour may recall, under the...
So what do you say is the implication of that? There's a mistake, but what happens?
It's a fundamental error,
Okay,
a
and
legally unreasonable approach to considering Assessment Report 86.
so fundamental error, which leads it to be what did you say? Leads the authorisation to be.
Yes, it leads the authorisation to be void because
There's
there
a
is
bit of
no...
a gap between those two propositions.
Well, let me try and connect it up.
You
Your
say,
Honour.
you know, there's an unreasonableness thing happening in there.
What I need to show, Your Honour, on this ground, because it's framed as legal unreasonableness,
Yes.
is that something has gone so seriously wrong with the reasoning process in the statement of reasons as to mean that the minister's determination is legally unreasonable.
And you say an error saying that something is consistent with an environmental impact statement and no assessment report when it's inconsistent is such a fundamental mistake in the reasoning process as to render that determination legally unreasonable.
Yes, because this is not just any fact. This is the environmental assessment report is a mandatory relevant consideration.
Hang on, environmental assessment report. A mandatory consideration. And it's, what section is that?
That's 82 of the mining.
82.
And as the minister rightly acknowledges in the chapeau to the bullet points, she's required to consider it.
Yes.
So there's a fundamental error in relation to the assessment of something that is a mandatory relevant consideration, and that's what I say gives rise to the jurisdictional error. Now,
Yes.
to just connect the dots that Your Honour flagged, of course I need to show that is material to the decision to get to
Yes.
jurisdictional error. So I need to show that that could realistically have affected the outcome. It's a low undemanding threshold, as the High Court said in Nathanson. And so if that's easily cleared in my submission.
And this is spelled out in more details in your written submissions?
Yes,
Could have affected the outcome, and you say, well, definitely could have, yeah.
yes. Well, a key part of the unplanned closure plan is inconsistent with the recommendation that the minister thinks she's complying with.
Yes, all right.
Now, a point taken against us in this regard is that the EPA's recommendation only related to planned closure and not unplanned closure.
The defence says EPA recommendation related to planned closure only. That's a reasonable point, isn't it?
No, Your Honour. It represents a misreading of the EPA's reasons, and can I show Your Honour why? If I can
Yes,
see-
hang on. Yes, show me why.
Assessment Report 86 is at tab 130. It's in the second volume of Your Honour's hard copy materials.
Do you have it, Lewis? Do you have that one? No, I don't think so. Have a look. There's a... It was in that first...
The second volume of the hard copy materials, tab 130.
Thanks. Lovely.
If Your Honour goes first to recommendation 12 at page 4425.
Yep.
That's the recommendation that I've referred Your Honour to as soon as practical after the cessation of mining. So there's no limitation there on early closure or later closure.
Hang on. So it does, yeah, so... No limitation on planned or unplanned, so...
That's right, Your Honour, and then that reading of it is confirmed if Your Honour goes forward to page 4465.
Yes?
And if Your Honour looks at the bottom of the page, there are some bullet points. If Your Honour could read the last sentence of the paragraph above the bullet points. NT, Environment Protection Agency, considers, at a minimum, controls to be implemented at the MRM site in early closure include : and the fourth one is relocation of tailings to the pit, with options to mitigate any ongoing seepage at the tailings storage facility.
Yes, so that's recommendation 22. Refers specifically to early closure.
So my submission, recommendation 12 is clear in its
And-
terms in the sense that it's not
Relocation of tailings to the pit. Okay,
so that was the requirement, and as a result,
pretty clear. And as a result?
it can be seen that in fact the approach in the mining management plan was inconsistent with these
Yes.
recommendations, and the Minister was fundamentally wrong to say it was consistent. That's then underscored by the fact that there were two documents within the department which said in express terms that it was inconsistent. The first of those is, it's in Your Honour's, yes, in Your Honour's hard copy bundle, tab 26. That's the first volume of the hard copy documents.
So, tab 26.
Now, I don't think I've been to this document before, Your Honour.
No, you haven't.
I tender it.
All right. Can I have that one, please, Liz? Oh. Tab 26. What are we up to?
15, Your Honour, P15.
Are you sure? I don't think so.
No, Your Honour, I'm not.
P16,
It is
thank you.
16, the native Excel file was
The
15.
P16, sorry.
Sorry, Your Honour.
P16 is tab 26, what is it? Assessment of January 2020 MMP. Yes?
Now, this document appears to have been before or available at least to the Minister at the time of her decision, but it confirms, if Your Honour goes forward to page 506, under the heading Domain 5 dash Tailing Storage Facility. The tailing storage facility rehabilitation cost is based on in situ capping. The department notes that this is inconsistent with Northern
Yes.
Territory Environment Protection Agency assessment report. And there follows an explanation there of why they're nevertheless going to stick it in the pit. Keep it in situ, not put it in the pit. But it remains the case that the position being there is it's inconsistent.
So you're saying that to be reasonable, the minister's reasons would have had to have said, look, it's inconsistent, but nevertheless I'm going to approve it because the inconsistency doesn't matter for these reasons.
Exactly. And then what she would have had to have done is notify the Environment Protection Agency of the inconsistency.
And then table that in Parliament,
Table that in Parliament, yes.
none of which was done.
And then the second document is not yet in Your Honour's hard copy folder, but it's about to be. I have a copy here.
Thank you. And where is this? Where does this come from?
This is volume 5, tab 70.
What's it called?
Memorandum.
Okay. Memorandum to Minister, to the Minister, 9th of October 2020. So memorandum to the Minister, 9th of October 2020, from volume 5, tab 70, will be exhibit P17. Now, what am I looking at?
So it's a memo from the Chief, from an advisor to the Minister on the 9th of October 2020. So that's a little over a month before the decision was being given in this case. And under the heading recommendation, that to you, and then the second black bullet point, which then has beneath it the second hollow bullet point.
Yes?
MRM's proposed TSF unplanned closure scenario is inconsistent with NT-EPA recommendation 22, and it cannot be demonstrated the environmental objects associated with this scenario have been developed and reviewed in consultation with those people. So this is something that the Minister was alerted to. And nevertheless, the Minister concluded in the statement of reasons that there was consistency. finally, to close this out, after some complaints were made after these decisions about this matter,
After the decision.
and
What relevance can that have to anything?
it's relevant, Your Honour, because it shows what would have happened at the time had the department done the sensible thing and told the EPA what it was planning to do and asked for the EPA's views. But that didn't happen before the decision. It did happen after the decision.
Yes.
And
What happened?
so the letter from the department to the EPA is at tab 114.
So the department wrote to the EPA saying what?
And
So I meant to the Environmental Protection Authority,
yes,
tab,
volume 6, tab 114.
yes, and that's going to be exhibited, is it? You're handing that up?
Yes, Your Honour. Plaintiff. Oh, that's in your hard copy bundles, Your Honour. It's tab 114 of the second volume.
That's the other one. Do you have that? Thanks, Lucy. So, let's exhibit that. Exhibit P18 is tab 114, but what is it? It's a letter from
the CEO of the department, whose name is Sean Drabsch.
let's just say CEO of Department of Industry, Tourism and Trade, to an NT Environment Protection Agency, dated 22nd of August 2022, will be exhibit P18. Oh, what's the relevant part of it?
Paragraph 2 identifies recommendation 12 of the assessment report. Paragraph 3 says that it's the department's understanding that recommendation 12 was made in relation to planned cessation rather than unplanned or early closure. And then under the heading unplanned closure, paragraphs 4 and following, the justification is put forward for not doing what the EPA recommended.
What's paragraph 9 all about?
Paragraph 9 is a reference to a meeting that took place between two different departments of the government. And it said there that the Department of Primary Industry and Resources consulted another department, the Department of Environment, and then at 11 it said they were advised that they didn't need to further notify the EPA.
When you say that's just wrong.
It's wrong that they don't need to notify the EPA, and the advice they're receiving is from the other department, not from the EPA. Now that letter goes off, and then the response from the EPA is in the additional volume of materials that I handed up just after the short adjournment.
The response from Environmental Protection Agency dated, what's the date?
25 November 2022.
5 November November 2022 will be exhibit P19.
And
Wait a minute, just let me find it. What's its tab number?
it has no tab number, Your Honour. It's
Not in court book, is that the one?
not in court book. It came
Righto,
in
got it.
after the court book was, it came in after the court book was prepared and we attached it to our reply submissions.
Okay. So, which bit am I looking at?
If Your Honour goes down to the fourth paragraph beginning the NT EPA's of the view, so we rely on that, Your Honour, that if the straightforward inquiry had been made with the EPA prior to the decisions being made, as it should have been, it would have been obvious, or the EPA would have made its view clear that there was an inconsistency, in the same way that certain members of the department have reached the same conclusion, contrary to the minister's statement of reasons.
This shows you that if they'd notified the EPA in a timely fashion, the minister would have been advised of the inconsistency and
Yes, Your Honour, and would have not, presumably not made the error that is contained in the statement of reasons.
or not advised, because the minister was advised, say alerted to the inconsistency and perhaps have avoided the error. All right.
Your Honour, those are my submissions on the third issue, and could I just flag that Your Honour may have seen from the brief opportunity Your Honour's had with the written submissions that a load of friends says as a backup, even if we're right,
Discretionary.
file to grant relief.
Yes.
We've dealt with that in our reply submissions. It's really a matter for my learned friend to develop,
All right.
but the burden is on him, Your Honour, to show that it is crystal clear that there could be no useful result in Your Honour granting relief. And
Yes.
so is the-
All right.
Those are my submissions.
All right. Well, look, thank you very much for that, Mr. Jones. I know the time, so we will adjourn for the day. And Mr. Lloyd, do you anticipate that you will take all day tomorrow?
I suspect most of it. I'll try and leave my friend some time for reply.
Okay, thank you very much. Can I just flag something, Mr. Lloyd? You have a very soft voice and my hearing is not the best.
Does this magnify, or it's only for the?
It's just for recording purposes.
Okay, I'll do my best to I'll do my best to speak up, Your Honour.
Thank you very much. All right, well, I'll adjourn for the day. Thank you.
Parliament will stand. The Honourable Court now stands adjourned.
Do we tender everything?
I have a little.
Oh, you do?